What happens to my parents' outstanding debts after they pass away? When a loved one passes away, dealing with their financial legacy can be a complex and emotionally challenging process. One of the most pressing questions that often arises is, what happens to my parents' outstanding debts after they die? This concern touches on issues of inheritance, legal responsibility, and the intricacies of estate management. Understanding the fate of parental debt after death is crucial for both peace of mind and proper financial planning. While the general rule is that debts don't pass directly to heirs, the reality can be more nuanced depending on various factors such as the type of debt, state laws, and the composition of the estate. Let's explore the key aspects of this important topic. 1. The deceased person's estate is responsible for paying off the debts when a person dies. Their estate, which includes all assets they owned at the time of death, becomes responsible for settling the debts. This process, known as probate, involves identifying all assets and liabilities, paying off debts, and distributing any remaining assets to heirs. The executor or administrator of the estate is tasked with managing this process. They must notify creditors of the death, inventory the estate's assets, and use those assets to pay off valid debts before distributing any remaining assets to beneficiaries. This ensures that the deceased's financial obligations are met to the extent possible before any inheritance is passed on. 2. Debts don't automatically transfer to family members or heirs. A common misconception is that family members automatically inherit the debts of the deceased relatives. In most cases, this is not true. Debts belong to the individual who incurred them and, upon death, to their estate. Family members are generally not personally responsible for paying off the debts of their deceased relatives, unless they co-signed on the debt or are otherwise legally obligated. This protection ensures that children aren't burdened with their parents' debts. However, it's important to note that while heirs aren't personally liable, the value of their inheritance may be reduced if the estate must use assets to pay off debts. 3. Co-signers or joint account holders may be liable for the debt. While most debts don't transfer to family members, there are exceptions when someone has co-signed a loan or is a joint account holder. In these cases, the surviving co-signer or joint account holder becomes fully responsible for the entire debt. This is because when you co-sign a loan or open a joint account, you agree to be equally responsible for the debt. For example, if a parent and child are joint holders on a credit card, and the parent dies, the child becomes solely responsible for the entire balance. This is why it's crucial to carefully consider the implications before co-signing loans or opening joint accounts, especially with older family members. 4. Secured debts, like mortgages, are typically paid from the sale of the associated asset. Secured debts are those backed by specific assets, such as a house for a mortgage or a car for an auto loan. When the debtor dies, these debts are usually handled by selling the associated asset. For instance, if the deceased owned a house with an outstanding mortgage, the executor might sell the house to pay off the mortgage. If the sale price exceeds the debt, the excess goes to the estate. If it's less, the lender may claim the difference from the estate. In some cases, heirs may choose to take over the payments to keep the asset, but this typically requires refinancing the loan in their own names. 5. If the estate lacks sufficient funds, some debts may go unpaid. When an estate doesn't have enough assets to cover all outstanding debts, it's considered insolvent. In this situation, debts are paid according to a priority order established by state law. Typically, secured debts, funeral expenses, and administration costs are paid first, followed by unsecured debts like credit cards. If funds run out before all debts are paid, the remaining lower priority debts simply go unpaid. Creditors may write off these unpaid debts as losses. This is why it's crucial for executors to carefully manage the estate's assets and follow the legal order of debt repayment to avoid personal liability. 6. Creditors have a limited time to make claims against the estate after a person's death. Creditors have a specific time frame, known as the creditor's claim period, to file claims against the estate for outstanding debts. This period varies by state but typically ranges from a few months to a year. The executor must notify known creditors of the death and the deadline for filing claims. Creditors who fail to file claims within this period may lose their right to collect the debt. This time limit helps ensure that the estate can be settled in a timely manner and prevents unexpected claims from arising long after the assets have been distributed to heirs. 7. Some assets usually pass directly to beneficiaries without being used for debt repayment. Certain assets, known as non-probate assets, typically bypass the estate and transfer directly to named beneficiaries. These often include life insurance policies, retirement accounts, and assets held in living trusts. Because these assets don't go through probate, they're generally protected from the deceased's creditors. This means that even if the estate is insolvent, beneficiaries can still receive these assets. However, it's important to note that if the estate was named as the beneficiary of such accounts, or if no beneficiary was named, these assets would become part of the estate and could be used to pay debts. 8. Spouses in community property states may be responsible for certain debts in the 9 community property states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. The rules regarding debt after death can be different. In these states, most property acquired and debts incurred during the marriage are considered to belong equally to both spouses, regardless of who actually earned the money or took out the debt. This means that when one spouse dies, the surviving spouse may be responsible for paying off half of the couple's community debts, even if they didn't personally incur them. However, the deceased spouse's half of the community property is still used first to pay off the share of the debts. 9. Executors or administrators handle the process of settling the estate's debts. The executor, named in the will, or administrator, appointed by the court if there's no will, plays a crucial role in settling the deceased's debts. Their responsibilities include notifying creditors of the death, inventorying the estate's assets and debts, filing necessary tax returns, and paying valid claims in the correct order. They must also ensure that no distributions are made to heirs until all debts and taxes are paid. This process can be complex and time-consuming, often requiring legal and financial expertise. Executors can be held personally liable if they mismanage the estate, which is why many choose to work with attorneys and accountants to ensure they fulfill their duties correctly. 10. Specific rules can vary by state and the types of debt involved. While general principles apply across the U.S., the specifics of debt after death can vary significantly depending on state laws and the types of debt involved. For example, some states have filial responsibility laws that can, in rare cases, make adult children responsible for their parents' unpaid medical bills. The treatment of taxes, both federal and state, can also vary. Additionally, federal student loans are typically discharged upon death, while private student loans may not be. Given these variations, it's often advisable for executors and heirs to consult with local legal and financial professionals to understand the specific rules that apply in their situation. Thanks for watching the video. Please subscribe.